And the Doctorate Association is a political independent, not-for-profit organization with a collection of over 4,000 PhD members and professionals and experts. It is a global platform that helps doctoral students and scholars to participate in the local community, supporting them in academia, career planning, and cross-cultural communication. And this talk is called Online Salon. It is an online knowledge sharing meeting held every month and is freely open to everyone. So today we have Dr. Li Luo to give us a talk about the copyright dilemma in the age of AI. And Dr. Li is an associate professor in law at Coventry.
Sorry, it's not associate professor, it's an assistant professor.
Sorry. An assistant professor in law at Coventry Law School, where she teaches intellectual property law, international trade law, and international business law for both undergraduates and postgraduates. And her current research focuses on the digital transmission and advanced technology, including the application of artificial intelligence in creative industry and its implication to the intellectual property law and the regulation. So without further ado, now I will give the floor to Dr. Li.
Okay, thank you very much, Zihao. It is very glad for me to be invited as the speaker in the online salon organized by the Doctorate Association and sharing my research with all of you. Well, because of the internet problem, I will turn off my video, but you can still hear my voice and also the shared PowerPoint slides. Let me just okay. So the topic that I discussed today is a copyright dilemma in the age of AI. I will explore the implications of AI to the creative industry and the surrounding copyright challenges. Because of the time, I would not talk all of those challenges in the copyright context, but probably will just give you some examples and mention about the most prominent ones. Before the appearance of artificial intelligence, no matter how cutting edge the technologies, human beings are the leaders, direct controllers, and operators to make the technology work, and also complete complicated tasks that human beings cannot do by themselves. So no one doubt the technologies are treated as the best helpers and assistants to human beings. However, since AI has been developed in recent years, it brings significant changes and concerns. This is because the humans realize what AI brings, and not only convenience and enhanced technology experience, but also an advanced independent capability of completing tasks with less or even little human engagement. Well, so probably we need to understand first what the AI is. There are quite a lot of definitions to illustrate what AI is. For instance, Marvin Minsky, an American AI scientist, defines AI as a science of making machines do things that would require intelligence if done by men. Some of the scholars also divide AI to different categories based on its smart level. So for example, we can see that they divided AI to 3 categories at least: narrow AI, general AI, and super AI. So through the PowerPoint slide, you can see how they define the AI. Well, mostly they define the AI based on the autonomous level and the decision-making level. And we know the development of data, computational power, and algorithms Three pillars of the success of AI system results in an advanced AI development. So AI can engage the creative activities more independently and with less human interventions. So now I'm gonna give you some examples on how AI has been used in those creative industries. The first one is the music sector. So, for example, AI has been widely applied to the music industry and is brewing a renovation in this area. So applications like Underscore, Dudig, Hungry is a Chinese app. All of these, Underscore, Dudig, Hungry, make music creation become an easy 1-minute task for public users. And so the public users just need to input, for example, choose a mood, style, tempo, or length. Then the AI system could generate a soundtrack, and then the public users can share and post those AI-produced music into social media for any fun purposes. Melodrive can help game development companies reduce their music cost up to 90%, since this AI application allow these companies to create custom soundtracks via AI system. So that means they through the AI system, Melodrive, the game company can generate the music, simulation the music, rather than paying any license fees to the human creators, human musicians. So this will decrease quite a lot of cost for those companies. And also there is another Australia-based startup, Splash Pro. This company created Splash Pro product, and this is a perfect human musician's assistant or collaborators, you can see, during their music creation. So it is predicted that AI would play significant roles in 3 lines at least of the future music industry, according to the development of AI music applications. So, so that would be, first of all, AI would be a fantastic assistant or even independent music creation contributor. And secondly, self-entertainment. And this is what I said, that the public users can use those AI applications to generate music in a very easy way and share their music into social media. And also another potential market, probably in environment simulation. So, for example, those background music in commercial and public sectors like games, restaurants, shopping malls, and other public areas may be largely occupied by AI-produced music in future, because of the less cost. You don't have to pay any license fees to the human musicians. Well, another example that I would like to introduce is how AI is applied into the fashion industry. So, well, AI has been applied in many stages of the fashion industry, such as predict the fashion trending and the demand forecast, engagement of creative design. So this includes both assisting human designers to fashion design and forcing generating design independently. In 2018, the Italian giant e-commerce company launched its first collection, which is called 8 by Yachts, the first fashion collection designed with the help of AI. So the AI software generated a dynamic mood board through the influencers' posts on social networks, online magazine articles, and also yacht sales data and the customer feedbacks. So the human designers could create clothes and accessories based on that mood board. Besides, AI has been used in inventory operation and supply chain management. So for example, Alt is a large e-commerce merchant selling fashion and lifestyle products in Germany. And it uses deep learning algorithm system to predict customers' buying preferences before they place the order. And you probably have been noted that the AI has been applied in enhancing customer experiences as well. So, for example, AI has been used in to help consumers enhance their personalized shopping and recommending consumers fashion products like those chatbots, image search, in-store smart mirrors, etc. So you can see that AI is everywhere in the fashion industry. So it can be said that the whole fashion industry is significantly changing and is influenced by the application of AI as well. This innovative technology of AI bringing the fashion industry towards to a more customized and efficient way at both online and offline shopping markets. Well, while AI's independence capability has been applied into the creative industry, a series of issues raise concern. One of the concerns of the application of AI is about AI-produced output in the creative industry, because there is a fear that AI may, well, in future, if it is smart enough, will replace largely the human creators in creative activities. And if it is, then whether such AI-produced outputs should be protected by copyright. I think the first, probably one of the most prominent issues is the authorship in the AI-produced output. In other words, can AI be qualified as an author in existing copyright law? Well, if we look at the international level, Berne Convention for the Protection of Literary and Artistic Works actually does not give any definition of authorship. However, if we look at those specific articles, sections, then we can actually see that the Berne Convention indicates to return the human-centered notion of authorship and the author rights. This is because the Berne Convention grants more rights to authors. Obviously, only human beings, I suppose, that will be giving or will be granted the moral rights, but it is very difficult to imagine that how you can grant more rights to machines. Another point that we can see is the Berne Convention provide a lifetime protection term. So the like author's lifetime plus a certain period of protection after the author's death. So obviously, human beings have this. It makes sense that if this is human beings, and then you set up this regulation of the lifetime protection term, but it doesn't make any sense if this is a machine, and you provide such protection term. And you know that the Berne Convention has been established in 1886, and I'm sure that at that time nobody would imagine that one day machine would be engaged in any creative activities. So at that time, people only focus on humans' creative activities and how the law could protect the human contributed to creation. And if we look at the national level, first of all, we can look at the United Kingdom. So the Copyright Designs and the Patent Act of 1988, Section 9, subsection 1, states clearly that the author in relation to a work means the person who creates it. Well, here I would say that the CDPA 1988 also provides a special section for computer-generated works, which some people think it can be used for AI-produced output. And that is, I think, the closest regulation, closest situation as AI-produced output. However, if you look at section 9, subsection 3, you will see, well, for example, in an AI-produced design or AI-produced music, based on this section, the author must be the person or persons rather than the machine, because it mentioned that the author shall be taken to be the person by whom the arrangements necessary for the creation of the work are undertaken. However, the CDPA does not give further guidance on this word arrangements. So this means the necessary arrangement person can be, for example, AI designer, the program operator, or even the investors of the AI technology. So there is no clear interpretation on what does this mean, the necessary arrangement. So that means quite a lot of different parties can be treated as the persons matching this arrangement requirement. If we look at United States copyright system, well, we can see that besides of the section 313.2 of this compendium, you can also see that the attitude of the US Copyright Office, because the US Copyright Office provides a clear interpretation of authorship that they only allow the register an original work of authorship, provided that the work was created by a human being. And this followed an infringement dispute of a self-portrait of Naruto. I think that some of you probably know this photo or know this case. This photo is taken by this macaque monkey itself. So the central issue in this case is whether an animal can claim copyright and bring a copyright infringement claim under the US copyright law. But finally, the court determined that the macaque monkey is neither constitutional nor statutory standing to claim copyright infringement. This is because the judges found express words used in the US copyright law, which is imply humanity and necessarily exclude animals that do not marry and do not have heirs entitled to property by law. In other words, only human beings rather than any other animals can claim copyright. Well, if we look at China's copyright law, China's copyright law also clears that the works of Chinese citizens, legal entities, or incorporated organizations, whether published or not, shall enjoy copyright in accordance with law. And if we look at the recent two cases in relation to AI-produced output, which is the Fengling and Baidu case and the Shenzhen Tencent case, then we can see that Chinese courts try their best to find human intervention during the creative activities. And in the Fengling and Baidu case, in this case, one of the disputes is whether an analysis report about the judicial analysis of the film and entertainment industry automatically generated by a software could constitute a work under Chinese copyright law. The interesting thing is, although the court admits that its content satisfies the formality requirement of literary works, and its selections, judgment, and also the analysis of relevant data reflects originality to some extent. We know that in the copyright law, originality requirement is a universal requirement, and no matter which country's copyright law, then in purpose of a work to be protected under the copyright law, it must satisfy the originality requirement. And in this case, the Fengling case, although the court admitted that the work reflects originality to some extent, but the court held originality is not a sufficient condition to qualify a work, but a natural person creates a work is a necessary condition for a work to be protected under the Chinese copyright law. So you can see that a human author is also quite important for a work to be protected. In the Shenzhen Tencent case, the court gave its judgment in favor of supporting an AI-produced literary work to be protected under the copyright law, but the court refused to admit the software-generated works shall be protected by the copyright based on the rationale that the software is not an author. So you can see that in both cases, the courts try to find a human intervention. And if there are not enough human intervention, then these works are not able to be protected. Well, so we probably can see that most copyright laws in this world probably do not provide the door for the machines to be qualified as the author, and then its produced output can be protected by the copyright law. But I want to say is a recent patent case recognizing AI as an inventor perhaps could give us some considerations in this aspect. A human being, Mr. Stephen Thaler, creates an AI machine named Device for the Autonomous Bootstrapping of Unified Sentences. So here we simplified as DABUS. Well, several parallel patent applications about two inventions generated by DABUS, this AI software, are refused by the US Patent and Trademark Office, European Patent Office, and the UK Intellectual Property Office, with the primary reason that DABUS was a machine rather than a natural person or not a human being. However, the interesting thing is, on 28th of July last year, South Africa's patent journal South Africa's patent journal, published these inventions, which means South Africa is the first country in this world that grant a patent to an invention that AI is an inventor. And the South African's IP office is now open to objection based on patentability requirements, including novelty and inventive step. And while South Africa published the DABA's application in its patent journal, Australian court gave the world first judicial decision in the case of Federal Commission of Patents. Interestingly, the Australian judges recognize AI can be an inventor. This is because Australian Patent Act does not define the term inventor. So the Commission of Patents adopt an approach of ordinary meaning of inventor. So they towards the inventor as inherently human beings, which is defined in many dictionaries. Nevertheless, the court believes that this is a narrow definition, and this narrow view approach should not be taken to interpret this concept of inventor in the Patent Act, since the Patent Act does not have any specific provision to expressly refuse a machine to be an inventor. Well, these two examples perhaps show a future potential that AI maybe can be recognized as an inventor or creator in more jurisdictions. They also indicate that the government and the legal professionals are turning their ways of thinking to cope with the challenges that AI brings to the existing IP framework, because of the development of AI system keeps testing these IP boundaries and limits. Well, we can imagine, for example, if this is in a fashion industry, and if designers simply use AI as a tool to generate some trends and styles for their own designing purpose, it is quite easy to identify the authorship and ownership in that particular fashion design. Definitely, that should be the human designers. However, if AI is so advanced that it is able to recommend and generate fashion designs with very little human intervention. So for example, what if the human designer merely just check and pick up some recommended fashion design, or simply express some ideas and then the AI can generate a design? It seems, from my perspective, very weird to say that human designer meets the corporate criteria of originality. Because if you look at the EU levels, the European Union's requires that the originality criteria means the author's own intellectual creation, and also in the UK, the CDPA requires that the originality should be the author's sufficient skill, labor, and judgment. And if the human designer simply express his or her ideas, and then the AI do the rest of the work, how could you say that the human designers contributed ideas satisfy the author's own intellectual creation or embraces sufficient skills, labor, and judgment? And we also know that the copyright law does not protect ideas, but only the expressions of ideas. So if the AI is so advanced, then there's going to be an issue on who should be the author of these AI produced outputs. Well, obviously, the existing corporate law does not provide clear provisions on the threshold of human creator intervention in the AI-produced output. So I think that understanding what does AI have done in the creative activities is very important for us to identify this issue. Well, in my, I think, since 2019, the World Intellectual Property Organization organized a WIPO conversation on AI and IP policy, and I had already delivered an intervention report and also made a speech in the WIPO conversation about these AI-related IP issues. And in my intervention report to the WIPO, I divided the AI-produced outputs into 3 different categories based on the AI development progress. So the first one is a starting point, which is AI-supported outputs. These are related to the outputs that are made by AI systems based on handcrafted knowledge. This is described by John Launchbury, the director of the Information Innovation Office at the Defense Advanced Research Projects Agency in the United States. And this type of AI only execute human set rules. And such AI system need a full intervention of humans and also in the substantial control of human beings. So from this point of view, the human beings are the authors of those AI supported outputs, because the AI is more like those electronic tools which support the humans in the creative activities, but they don't have any decision-making capability. The second is what I called the middle period, which is what we are currently in the situation of the AI development. So I called it as AI assisted output. So these outputs are made by AI systems with statistical learning capability. So AI systems cannot learn and imaginatively predict themes with features beyond the data supplied by humans. So that is why we can see that today's AI, most of them need to be fed by a massive data. So the AI can be trained, could understand, for example, why cat is cat, why dog is dog. Then they need to learn massive photos, pictures of a cat to recognize this is a cat. And obviously, if you wanted this type of AI to draw a cat, then it can draw a cat based on what they trained. So they cannot predict or draw those themes imaginatively beyond the data that they are fed. So from this point of view, we can see there is a constrained decision-making and the prediction capability. Well, this is definitely compared with the freedom of decision-making and the creativity of human beings. Because for the humans, then when we create, for example, create a work, let's say drawing a picture, then we have an idea in our head, and then we will draw this picture, and that is how we create a theme. But for the AI, they cannot do such imagination. beyond the data. However, what we can see is if the human beings would like to let the AI to join a picture, for example, the human beings cannot able to they are not able to get exact result on what the AI would draw, because AI could make a limited decision based on the trained data and draw a picture. And so this might be an issue on whether AI's limited decision making can be treated as a certain element of creativity, because the human beings actually gave AI some limited decision-making capability and the limited freedom to draw a picture. So that is why the human users would not able to predict the exact result that AI produced. Well, most current AI-produced outputs, a variety of areas related to this category, as I mentioned before. So, for example, the neural style transfer in image, and also generative adversarial networks and the creative adversarial networks. The GANs and CANs can generate artifacts based on data. But I would say that the current AI, current type of AI, is still quite. What we can say is that, from a human's perspective, it's so-called creative process is quite stupid. If I explain to you how GANs work, then you can understand. So basically, the GANs, in the GANs, the generator makes painting based on the data, whereas the discriminator's mission is to point out the difference between the human-made painting and the generator-made one. The generator learns from every single failure until produces an image that can fool the discriminator. So from this perspective, the whole process is likely to make a painting by thousands times of modification until this painting looks like a real-life portrait. To some extent, it can be said this resulting output is a new artwork, but its producing process is so clumsy and subverts humans' imagination on how an image is painted. For these AI-assisted outputs, then we can see at least two scenarios related to the copyright. The first one is, so for example, if the fashion designer or the musicians use AI system to produce a design or a music based on input data, let's say a massive fashion design images, trends, styles, or a massive music works or soundtracks, and modified the AI produced outputs to produce the final version. It is an issue on whether the human author should be treated as the sole author of such final version, because it is more like a kind of like adaptation based on AI produced outputs. And the second scenario is, we know that this type of AI relies on massive data to produce a design or to produce a music. And such design or music may be similar as that of a pre-inputted human design or human music works. In this case, it seems unclear that whether or not AI's use of data for training would infringe human designers' copyright. However, it can be seen that if AI systems to produce fashion, design, or music for commercial purposes in the near future, it is necessary to identify the legal status of those training data. And that is also one of the issues that WIPO conversation discuss as well. And we are actually in the process of from this middle period towards to the future direction, which is AI generated output. So the AI, no. Sorry, just give me 1 second. Sorry everyone, it was my son because of the storm. The school is closed and he has to stay at home. Okay, so the third type of AI would have the capability to construct a contextual explanatory models. So that means the AI system in those states would understand and perceive the real world by themselves. So they are no longer to learn from massive data, but learn more from an understanding of the real world and reason with it. And from my perspective, the point that the AI can abstract perceived information and start making themselves think about the meaning of them indicates a sign of creativity. Last year, 2nd of August, Tel Aviv University and Inventor company published a paper that shows their success in blindly training AI system called Style Gananda to produce imagery. So we know that this Style Gananda can produce images from a specific domain with merely a text prompt rather than seeing any image. So normally we know that in this stage, the AI needs a powerful data to learn images before generating one. So it is not possible for AI to generate an image that is never saw it before. But the Style Gananda can do that. It can generate images based on text-based prompt without pre-seeing a single image. Well, I think it perhaps an important starting step for the AI system to progress from this statistical based learning level to the contextual explaining stage. So you can think about what if one day a human creator just either talk with AI about his idea, and then AI produce a design or music or any other creative work based on his text description. Then can we still say the human creator contribute creativity in that AI produced design or music or any other output? I think probably the answer might be negative, or at least we are not sure. So I think we need to consider a legal system to cover and respond to relevant legal issues due to different types of AI engaged in these creative activities. Last October, UK Intellectual Property Office called for open consultation on AI and copyright and asked for public comments on their provided 3 policy opinions in regard to the regulation on computer-generated works in the CDPA 1988. They provide 3 options One is no legal change. Second, remove the protection for the computer-generated works. That is section 9, subsection 3, if my memory is correct. And also the third one is replace the current protection with new rights of reduced scope to cope with the issues on AI-produced outputs. Because UK IPO tries to understand which option could have an incentive effect in encouraging new AI-produced outputs and the investment in AI technology. And if they made the replacement option, this may trigger a copyright legal reform in this area. Well, I think for the existing copyright system, the most difficult thing is the AI-produced output or the AI system itself trigger the fundamentals of the existing copyright system. One is the originality requirement. The second is human authors. So if we need to think about to protect the AI-produced output, to incentive AI investments, and encourage the technology development, we probably need to think about whether or not we can set up any sui generis system in the existing copyright system, considering that we are still in the statistical learning level, and AI is not smart enough. However, definitely we can foresee that in the near future, AI would be so smart. If that is the case, and if the AI can think like us, can reasoning, can explain based on surrounded words, and then made those outputs, whether or not we need to think about a new law specifically for those robotics or smart machines is an issue, or is a thing, I think, that we need to think about it. Because no matter copyright law, patent law, or other IP laws, they are primarily designed to regulate human creative activities or human innovations. So the engagement of AI system in the creative industry would bring both opportunities and challenges, and also both innovations and renovations. Well, the applications of AI in both assisting creation and independent creation is and will be a new normal in the creative industry. So specifying AI's functions in the creative and innovation activities, as well as recognizing AI's partly or largely or even fully engagement in those creative process would be the key for all the human legislators and industry workers to consider an appropriate legal system to respond to the radical changes because of the technology contribution. One thing we must recognize that is a single law can resolve some issues, but not all. Thank you very much, everyone, for participating in the event. My presentation is ended.
Okay, thank you, Dr. Li, for your wonderful talks. And your talk shows the relationship between the law and the application of AI. Actually, I learned a lot from your talk. So now, due to the limited time, I will give the floor to our audience. So it's allows us to ask one questions. So if anyone has any questions, please raise your hand by clicking the button, and also you can type it in the chat box. I think there is already one question in the chat box. So Dr. Lee, can you see it?
Yes, it's Jason Lee, isn't it?
Yeah. Because
okay. Well, yes, I think you think about the sui generis right, which is quite useful, because we can see that even if I said that in the near future, we probably need to think about another law, but at this stage, well, probably I think at least in the next probably 5 years, I don't know, we are still in the statistical learning level. So that means AI still need quite a lot of data to be trained. And some of these people think about that when we talk about the data, then the data that AI need for the training purposes, those data, some of those data are raw materials. Some of them are actually the output that are protected by the existing corporate law or other laws. So how to identify this is a problem. And also another issue, I think, is when AI generated works, because I had get a conversation with those AI scientists, computer scientists, and I asked them that how AI generated work based on those data, and what they told me is that when the AI generated those output based on those data, mostly they are trying to find out those factors, features, rather than what we think is like the expressions. So those kind of themes, they don't think that it belongs to sort of those expressions of ideas. And if that is the case, it's like they are abstract those common features, elements, rather than those descriptions of those data. And if that is the case, then what I'm thinking is, if you design something, or if you made a work based on some common features that everyone can use, can you think that those data should be protected and should be get some kind of like a consent in advance? So that is quite interesting. But I can see that if you look at WIPO's conversation and those submitted intervention reports, interesting thing is those like publishers, associations, musical, radio associations, they always feel their report always say that, oh, they need to set up some sui generis systems, or to set up some license to protect those data, because AI use those data to be trained and produce output. But if you look at a very few, not too much, very few reports from those computer science perspective, those industry workers, they would point out this point. So what AI actually use in those data, do they use those descriptions, expressions of those data, or they simply abstract those fundamental features or some kind of like information, rather than the the description. So if that is the case, then should we still regard this as something that we should protect it through a copyright perspective, or should we think they can be freely used? But what I can see that people probably would be tolerant about if the AI produced output and also the use of AI is for any non-commercial purposes use. But they probably would not agree with anything that for commercial purposes. But another problem is normally, though at the first point, those use of AI and also the data for the data training, they will start with the non-commercial purposes, but perhaps during the process, they will start with some commercial use. So if that's the case, then how can we identify and at which point we should regulate them differently? That is an issue as well. So it's quite difficult to give you a clear answer because the WIPO, I think since 2019, they only organized 4 sessions about the AI and the IP policy conversation, and there are quite a lot of issues that they are still discussed at this moment. Yeah.
Okay, thank you, Dr. Li. It's a very interesting question and a very useful answer. And I think it's already the time to close our today's talk. So let's thanks again Dr. Li for her excellent talk, and also thanks everyone to participate in this talk. And we will have another talk in the next month. So please keep an eye on our website and see you at the next time. So,
okay, thank you very much. Bye-bye.